We see you, Francis. But what do we matter? We're just the great unwashed. What's more important is that the Supreme Court sees you. Francis, the world is watching. The world sees what's going on.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It is Tuesday morning, the 12th of December, and well, what a night last night was. Just before midnight, my time, I happened to check Twitter, and everything was kicking off because the Supreme Court had replied to both writs of mandamus and prohibition that Mark Lehman and Cara Wernicke have written to the Supreme Court of Indiana on behalf of Richard Allen. You know the story. You know it all if you've been following this case. The first writ, the procedural one about records and such, was denied. The most important one, though, was not. There is a hearing on Thursday, January 18th, 2024, at the Supreme Court of Indiana in Indianapolis. The justices of the Supreme Court, the gods of law, will hear both sides of the argument. What does that mean? It means that although writs of mandamus and prohibition are very rarely accepted, passed, agreed upon by the gods of law, this time they've not just denied it. They want to hear what Francis has been up to. Each side has got 30 minutes to present their case. Each side cannot bring evidence and testimony, can't do that. They've got to argue what they put in their paperwork. And each side has got 30 minutes to present what they can, because the gods of law are going to sit there in judgment and ask them as many questions as they like. So what we're going to do in this video is we're going to remind ourselves what was said in the second writ of mandamus and prohibition that we're talking about, the one that ends 311. And we're going to see what Francis is going to be arguing. But this is the brief. They're requesting three things that the gods of law need to make judgment on. They want Richard Allen's rightful attorneys, Brad Rosie and Andrew Baldwin, reinstated. They want a speedy trial within 70 days of the issuance of the writ. And they want Judge Francis C. Gull gone. Now, I'm not going to go through 21 pages. I did a live stream going through all of this, what it means when this was new, and I've talked about it at length. However, I just want to read you a few paragraphs. Remember, this is the documentation that Richard Allen's side, and it's going to be argued by Mark Lehman, is referring to. And this is what the gods of law will be asking questions on. Over the next year, attorneys Baldwin and Rosie zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of the probable cause affidavit. They repeatedly requested a change in the conditions of his confinement due to the obvious effects the conditions were having on his physical and mental health. and they prepared a trial strategy with Rick after pouring through thousands of pages of discovery to prepare his defence for a January 2024 trial. Isn't it interesting that just the other day, Rick, after Judge Francis C. Gull had denied him being moved from Westville, where Ordinance guards, people who claim to be Norse pagan heathens, but wearing Odin patches, all right, so not Ordinance, but whatever, tasing him and videotaping his conversations with his attorneys, all highly irregular and just nonsensical. Lost nearly half of his body weight in just a few months. Yeah, after being denied, he was moved to Wabash Valley Correctional Facility. Did a video about it the other day, and I said I didn't want to speculate that Theodore Rakita, the Attorney General, who'd signed the order to get him moved, did he have some advanced knowledge of what was going to go on here? Interesting timing, that's all I'm saying. However, let's carry on here. During that time, Rick never complained to the court about his attorneys. On the contrary, he unequivocally stated his desire to have attorneys Baldwin and Rosie continue their zealous representation. Yet less than 3 months before trial, the court removed attorneys Baldwin and Rosie as counsel, citing its extrajudicial finding that counsel had engaged in gross negligence. At Rick's direction, attorneys Baldwin and Rosie entered appearances as private counsel, agreeing to continue representing him for free. But at a hearing held on October 31st, the court told Rick he'd had grave concerns about his defence team and that he was entitled to a vigorous defence, and that the court cannot and will not allow these attorneys to represent you. Rick's trial has been reset for a year from now. He has been forced to start over with new attorneys, friends of Francis C. Gull. At least William Labrato is, little Facebook friend.
Oh, your children are so cute, William.
Bet you go to little dinner parties and barbecues and shit like that, don't you? Yeah, I bet you do. The court's statements about Rick's counsel have completely undermined the credibility of Rick's proffered defence. And let's remember, ladies and gentlemen, that this was all done under the cloak of darkness. Not quite, because we've seen the transcript. Attorneys Baldwin and Rosie were ambushed. They were told to turn up for a hearing on the 19th of October. When Brad Rosie asked what this was about, he was told that he and Andrew Baldwin should turn up at Chambers, like at 12:30 or whatever. And it started off, talking about motions and stuff, and then it quickly descended, we've seen the transcript, into a preordained, what I can only describe as an ambush of attorneys Rosie and Baldwin. It's obvious what happened. Slick Nick McClelland, the McVillain himself, had brought all his witnesses, Doug Carter and Liggett and all them were sat there. Slick Nick knew to bring his witnesses. That's all we need to know about what a setup this was. The attorneys, Baldwin and Rosie, going for a chat, wanted to know what the hearing was about. So she said you could withdraw. Rosie said he would, but didn't. Baldwin said he'd withdraw, and she accepted his oral motion. Both of them, then, in the time between the 19th and the 31st of October, both of them put in paperwork to say that they were going to appear as Richard Allen's private counsel pro bono for free. All right, so they might have withdrawn under duress as public defenders at his request, Richard Allen wanted those attorneys to stay, and they were willing to stay pro bono as private counsel. They were approaching trial. Jury selection was due to start on January the 8th. They got all the work done. Yeah, they're going to lose some money, but they got most of the work done anyway. Anyhow, though, numbnuts herself, Frances C. Gull, said, "Oh, I just can't, I can't. You're disqualified." So when were they disqualified? 31st. Where's the evidence, Francis? Where's the evidence of all these things that they supposedly have done that constitutes gross negligence? Let's see what Francis is going to argue. This is Respondents Brief in opposition to Realtor's verified petition for writ of mandamus. So this is the documentation she's going to base her argument on. This court has never issued a writ to reinstate a criminal defendant's counsel, whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. The reason why the gods of law at the Supreme Court of Indiana have never done this before is because no numbnuts judge has ever gone this way before and just exercised power in a dictatorial manner. Listen, this is going to set precedents for years to come. The Supreme Court absolutely cannot have judges going rogue whenever they feel like it and disqualifying attorneys based on what the prosecuting attorney says. It just can't be done, right? It can't be done. Surely the Supreme Court has got to see that. She disqualified them just based on her own thoughts and opinions. They weren't given the opportunity to bring witnesses, to examine the prosecution's witnesses. Why was the prosecution bringing witnesses? Why was Slick Nick bringing a bunch of law enforcement officials as witnesses? What on earth? In disqualifying Rick's counsel, respondent did not violate an absolute duty. Moreover, Rick's remedies on appeal are wholly adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. What you're forgetting, Francis, is appealing to the trial court for reconsideration. Well, they did. And then what are they going to appeal against? Because there's no documentation to say why these fellas were disqualified. There was no hearing. There's no evidence. It's all in your head, Francis. So as well as this never happening before, Realtor's petition further fails on its merits. Sixth Amendment right to effective assistance of counsel outweighs his limited right to select his counsel. Well, you haven't proven that his attorneys were incompetent. Just your opinion. So, Respondent has discretion to remove relator's counsel, whereas here the record supports attorneys Baldwin and Rosie were providing ineffective assistance of counsel. Well, if I was one of the gods of law, I would say, where's the record? Where's the record? There's no fucking record. Where is it? There's no record. Even Theodore Rakita, Attorney General, made that point, that there's not enough information, there's no record to know whether it was right or wrong that these guys should be disqualified. Realtor's counsel failed on multiple occasions to take reasonable steps to safeguard confidential case materials. A mistaken email of Baldwin's own work product. Just the index of what was on a USB stick. Yes, it's a mistake. We've been through all this. The leak by Mitch Westerman. Why did he hold on to those photos for 2 months? Why were those photos already out? Why were they already out in December of 2022? Why were they already out? Made extrajudicial statements that had a material likelihood of prejudicing the case. So before the gag order, when you, Francis, put in place after the press release that Baldwin and Rosie put out on December 1st, 2022. But you've had all this time, you've had a year to complain about that, and you didn't. You didn't. Where's the documentation that you have reported these attorneys to whichever body deals with naughty attorneys? You can't put them on the naughty step now without warning them. You need to be watching Super Nanny, Francis. You're not very good at this, Francis, I have to say. Providing false information to the court. Where? Where did they provide false information to the court? Why are you believing the Warden of Westville? And then, surprise, surprise, a few days ago, Richard Allen's moved to Wabash. I smell a rat.
Rats don't smell, Michelle. How many times do I need to tell you?
I know, they don't smell. Before removing relator's counsel, respondent afforded relator with notice an opportunity to be heard through written submissions as well as argument in chambers. No, you didn't, Francis. We have seen the transcript. Do you not think that people will read the transcript? And it said, I don't want him in chambers. Oh, the Department of Corrections won't like that. I don't want him in my chambers. And then you sent him back to Westville. That's what you did, Francis. That's what you did. Too right, the world is watching. Too right, the world sees what's going on.